Head to Knoxville, don't be late. Baker's Live, it's gonna be great. June 5th and 6th, mark your date at Dollywood, we'll celebrate. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. Rides, fun, and meet and greet. Baker and pals, the crew's so sweet. Get ready for laughs, cheers, and thrills. Knoxville's the place, it's giving chills. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. June 5th and 6th, don't miss the fun. Meet Baker and friends, it's second to none. Baker and friends, it's second to
No, they are exactly the same length because I kind of run the same intro for 3 months at the time, and I try to keep them at roughly 2 minutes. I know they are a bit long, but it's also followed by a long stream, and I like making stupid music videos, and Baby Baker apparently likes this one, and Marissa hates it. So it's a 2-for-1. Welcome everyone. Good morning, good evening, good afternoon. I should do that because then Marissa would stress pee and hate me as enough that she would move to Denmark and beat me with a hammer. Hello, hippie chick. I didn't follow the first trial. I will give a summary. I can see more of you are coming in here. I'll do the spiel. I just started a little bit early because Brandon is always complaining that I'm late, even though I'm on time. Starts the live with, no, where's the expert? Exactly. Hey, MBM Esquire. Well, my outro stays the same. Sometimes I get the urge to, oh, there's another good clip, but I just feel like I got a good clip running. And I deleted the program that I normally made videos in, so it'll be fine. Hey, Mr. Fedorowski. Hope everything is better now down in Spain. Here, it's wonderful. Sun has been shining all day. It's 10 degrees. Sunglasses and shorts. That's what we need today. So Jamie will love it because it should stay the same over the weekend. A little cloudy, but around 10 degrees. And Iris will freeze her titlets off. Hey, Panella. Hey, Annie and Anya. And 80s and Hellraising. And Jemima. Yeah, I had a few good ones there. Maybe I need a... I should try and get It's Me, Jimmy into my intro. I took out... No, the pregnant pause has never been a part of the outro. I should do that. I need a video for when I do something in like 2 minutes when I run and pour the Friday beer and stuff like that. It's not like I never stream anyway, so why don't I just make more videos? It's a pretty good one. But sometimes you're lucky. This case that we're covering today. Hey, Zachary. Thank you so much, Jennifer. Yeah, I think I go around and look at some of the people who streams at night, and it seems like everyone kind of agreed yesterday. Everything we saw was absolutely the worst yesterday. I can say that I'm trying to put together a panel show for Sunday, 2 p.m. Eastern. Remember daylight savings time. I will have to figure it out because I'll have to figure out if you then will be 5 or 7 hours behind me. I think it'll be 5. Video Jesus have said yes, and we have 2 more guests that we intend to reach out to. One of them is we're waiting for confirmation, and the other one, I don't know if Marissa have reached out or will reach out. So can be a very interesting show on Sunday. Just saying it. No, if he in any way, and you could even tell that Bev changed the tune. So, Diane G. But, well, you were a late addition. I thought, should I go back in and change? It's Valhalla. Everyone knows Valhalla. But this case that we are looking at appellant brief in today is the Cara Rintala case. This is one of the first cases where I think we could say my channel kind of grew. Before that, I have been that guy who'd been on Dave and Nick's show. And then I did the Adam Montgomery Pew Pew. I got a little growth of that, but I think the Cara Rintala case was when people kind of came and watched it because of the case and because of they wanted to hang out here. And some of you are still here, and I still wonder why. But it's a case we picked up because it looks so weird. It was the fourth time in court for this case. It had a few nicknames: the paint drying case, the lesbian murder case. It was quite famous back in the day when it happened. It happened in 2011. It's been almost 2 years, so I'm not 100% on the facts, but I believe it's 2011. Cara Rintala and Anne-Marie Rintala is the first lesbian couple in Massachusetts where the spouse is accused of unaliving the other one. So that was quite famous at the time. That's kind of what we knew. As you know, on this channel, we jump blind into most things. And oh my God, was it absolutely the best case ever? Because this is where we got the corner kisser. These 2 women, even though they were lesbians and had lesbian relationships with each other, Cara had a boyfriend or a man friend over the night before the unaliving. Apparently, that made Anne very angry, and that's why the state theory is they got into an argument, and then Cara unalived her in the basement while their daughter were upstairs, drove around town, and hid that she had done and tried to give herself an alibi. And on the other hand, had the corner kisser. He was a work friend who worked at the fire station with her, who was only allowed to kiss her on the corner of the mouth. But he had been promised, and remember this is 2011, that if he got her the new iPad, he could give her a full-on smooch. This guy was married, but he gave her a credit card he never told his wife about, where she ran up, I believe it's $25,000 of debt on that one. She was supposed to get a dog from him as well. They were about to go out and get a dog either on the day of the unaliving or shortly after, and had, I think it was, they were gonna pay, I can't remember how much. Again, it's a little while back. They were gonna pay a lot of money for that dog as well, that she then also swindled kinda out of him. This weirdo kept sleeping in her sleeping bag at the fire station after she passed away. The police did look at him and say, "You're a little weird," and then found out that, well, he wasn't that weird, even though he lied about where he was on the day off. He had plenty of time to go do it after Cara had left the house, but no, he didn't do anything. He only had a kind of an alibi in the morning, and then he said, "Yeah, well, I was home all day." And also had another girlfriend who she had an on and off relationship with while she was married to Cara. This lady checked into her gym. She was seen checking into the gym, and then she went for a run outside of the gym. And I believe she was running for like 90 minutes or 2 hours, which have given her enough time to run to the house, do the deed, and run back to the gym. People looked at her, didn't find anything unusual. And also had a credit card. I believe she had a credit card from her with $10,000 in debt. But the only one who had a motive is to do it was her wife. Even though her wife and her, they had been, they had broken up, they gotten back together, they had restraining orders on each other, but as the police officer said, well, the first one through the door is the one who's the victim, which I find is quite disturbing that that's just how you do it. But apparently she was a victim because she was the first one to reach the police station, and Rintala. There was so much shenanigans going on, and she had the best defense attorney, Rosemary Scapiccio, who had the greatest Boston accent. Jamie loved her. She was doing it free of charge, trying to help her out. It's not her who's have signed this appellant, which is normally appeals are done by other people. But she was a wonderful attorney, really a good attorney. But it was a very interesting case. The first time they had a hung jury. The first 2 times they had a hung jury. Then the third time they got her convicted by way of a paint drying expert who testified that the ceiling paint that the body was found in must have been tipped over at this time, because it was, I've never seen that, but apparently you have something in America that's pink when you put it on, and when it dries it turns white, so you can see where on the ceiling you have painted. And he stated that, hey, look at this, it's at about this level of pink, so it must have been on the floor for X amount of hours. And here comes the funny little part, because that was overturned in the Supreme Court because he didn't have any way to testify about that, because you can't just use, well, I think so. And that is now the basis of the habeas corpus and the motion to dismiss in the Karen Reed case, Rintala versus Massachusetts. Because this expert had no expertise to testify in court about what he was alleged to be an expert in. That's why they want Dr. Wolf out. They want the ground hardness expert, it's not the habeas corpus and not the appeal, sorry. It's to toss the 3 experts that hanky-panky wants in, because they don't have the necessary expertise to testify about the subject they are purported to testify about. This comes from the Cara Rintala case, because this guy said paint dries at this amount of time, but paint doesn't dry in this amount of time, because you have what environment is the paint in, how old is the paint, was it stirred, was it disturbed? There's a myriad of things that can influence it. But then she had her 4th trial. That's the one we covered in 2023, early 4, maybe, where she got convicted of a lesser included and got 17 and a half years in prison. Had to serve 14 before she could be ready for parole, and she then had served, and now I'm just reaching because I can't remember it right now. She got 17 and a half years. She had to serve 14 and 2/3. But because she already served time before she had her appeal, had her conviction overturned, I think she needed to do like 11 years in prison. She had an adopted daughter she had with Anne, who was pleading for her not to go to prison. So they didn't get her on murder 1, which I believe was the first charge they had against her. But we will go through the facts again. I don't know why I just made it out of my mind, because I can't remember anything. Baker, is that the famous Little D t-shirt, and did you ever send her a reciprocal shirt in size XL? I never sent her a reciprocal t-shirt, and I know for a fact she is not a size XL. So I wouldn't do that, Zach. Why are you so mean? But it is my Little D gift. You were a painter? So was a famous guy from Austria. Watch out for painters. I think it's the fumes that can make them a little crazy. You want a reciprocal t-shirt? Well, then you have to send me a t-shirt. Then I have to make my merch manufacturer, who isn't my merch manufacturer, but I'm still trying to make it my merch manufacturer. I'll have that person make me a Box Wine True Crime t-shirt for you, and you're still a size 4X. But let's jump into this, because I also have to go and pack my stuff, because I have to leave my house tomorrow at 8 to go meet up with Jamie and Irish. Well, I said that's not the greatest, but I have someone I'm trying to force to make, so I know the quality would be a little better. But they are not jumping at the bit to be my manufacturer. But we have the Commonwealth of Massachusetts appeal called Commonwealth of Massachusetts v. Cara Rintala. And I love that, after watching all of the Karen Reed stuff, I love how great all of this is put up. Number 1, Juror 40. An accomplished college student had an individual right to serve without being discriminated against based on her gender. The prosecutor struck her when he did not strike similarly situated male jurors and admitted he was employing pretextual reasoning to insulate his challenges. This violated Cara's and the jurors' constitutional rights to equal protection. Jurors reported they were aware that Cara had been incarcerated for 5 years as a result of a prior trial. This extraneous information diminished Cara's presumption of innocence and the Commonwealth's burden to prove guilt beyond a reasonable doubt. This created irredeemable prejudice. Cara is entitled to a new trial. And the trial defense hinged on creating reasonable doubt due to police investigative omissions. The judge probably instructed jurors that they could consider whether such omissions may have led to significant evidence of the defendant's guilt or innocence, but then the prosecutor and judge told the jurors they could not speculate without giving a requested instruction harmonizing the speculations instructions with the instruction on police omissions. This cut the heart out of the defense and confused the jury. And look how wonderful it is. You have a table of content, and you can see, oh, you want to read about the first argument, go to page 13. I love this. It's so wonderfully made. I want to proudly wear a cream pie t-shirt. Well, I told you I got to get the tax stuff sorted, and then disclosures at work. It's going to take time. All I hear is... I don't hear, oh yes, let me set it up for you. Table of authorities, all the case law. Look, Special Pro Sector Brennan, this is case law. Isn't it amazing? There's a lot of it. Other authorities, constitutional provisions, and then we get into statement of But if you are buying a t-shirt on the merch site, I just say some of them have been a little bit hit or miss. I still wear my green hoodie a lot of the time. Elastic's not the best. My grifter t-shirts are great. I really like those. But I've just had some other t-shirts that wasn't super. Let's just say that. Statement of issues. Whether the prosecutor's strike of juror 40 based on her age was pretextual and therefore not genuine. Whether the judge should have granted a mistrial when the jury learned that Cara had been incarcerated for 5 years as a result of a prior trial. Whether the standard instruction on speculation confused the jury and undercut the defense when the judge also instructed them on the omission in the police investigation. Statement of the case. This is all the stuff that I have just told you. In October 2011, yes, a Hampshire County grand jury indicted Cara for the first-degree murder of her wife, Anne Marie, on March 29, 2010. I was off by a year. Cara was tried 3 times, February 20th to March 7th, 2013, hung jury, January 9th to February 4th, hung jury, September 14th to October 7th, convicted of first-degree red rum on a theory of deliberate premeditation. She appealed. The Supreme Judicial Court reversed the conviction. Commonwealth v. Rintala, that's the one they use in the Can Read case. She was tried for a 4th time on September 6th, 2023 to October 5, 2023. That's pretty good memory I have. It's a year and a half ago. And first names will be used for both Cara and Anne Marie for clarity. The jury returned a verdict of voluntary manslaughter. The trial judge sentenced her to 12 to 14 years of incarceration. Sorry, I got that off a little bit. Statements of facts. Cara and Anne Marie. Well, I won't tell if you won't tell. I just got sidetracked. Cara and Anne Marie were married and had a young daughter, Brianna. They were both experienced paramedics. Cara worked for the Ludlow Fire Department and worked for AMR Ambulance Company. They lived at 18 Barton Street, not that important. At March 29th at 7:12 p.m., police was dispatched to their home for a possible domestic. When officers arrived at the scene, they found Cara in the basement cradling Anne in her lap. There were paint on Anne's body and around the basement. Officers Gary Poehler and Mark Smith helped Cara move Anne's body to the floor. Cara walked upstairs with the officers. Once upstairs, she spoke with Poehler. State Trooper Jamie Magarian arrived on scene and was the lead investigator. Cara gave permission for Trooper to interview Brianna. Cara also agreed to participate in 2 recorded interviews with Trooper Robin Whitney. Dr. Joanne Richmond testified that Anne died of manual strangulation. Anne also suffered multiple bruises, abrasions, and lacerations to her head and body. Significant blood flow from these wounds suggested that she was still alive when she sustained them. Dr. Richmond opined that Anne had died 6 to 8 hours or more before first responders arrived. The Commonwealth called a second pathologist, Dr. Thomas Andrew, who concluded that Anne had died before 1 p.m. The defense called Dr. Jennifer Lipman. Dr. Lipman testified that Anne could have died 3 to 4 hours before first responders arrived, 3 to 4 p.m., given the evidence of a violent struggle. That has to do with the body temperature. The first responder did the armpit test. That's an international, scientifically proven test where you find a deceased person, and then I believe it was in this. No, this wasn't the case. Sorry, this was the one where they did the rigor test to find out how long she'd been dead by testing how far into. I don't have that anymore. I had a great picture of how to find out if how long people have been dead by using rigor mortis. He said that they found her with her arms kind of locked in front of her. So he took the arm and shook it, and that's how he determined how far into rigor she was. They say it's vicious on the Isle of Lesbos. The Isle of Lesbos is apparently a beautiful place. I had friends who went there. If you don't know and think Zach is just making it up, it is a real island in Greece. Apparently quite a nice island to go to. Kind of a party scene back in the day. I don't know if it is anymore. Hey, Candence. Yeah, he shook her arm and said, "Yeah, she's dead, and she's been dead for a couple of hours." I'm just sad because I need to see if I have that picture, because it was back when I still did my I don't do a whiteboard anymore. I'm too busy. Well, I'm just lazy. That's the thing. Don't I have it somewhere? I used to have everything in my folders. Daddy got a rigger. This is, of course, how you determine if someone is in rigor. This is also the famous case with Mark Lecola saxophone. That was every time CC picked up something, it came off like the saxophone. But this is how the first responder determined how long she's been dead. He shook her arm and could determine the time she had been decedent. Hey, MG, you were up late last night. And Iris is already in London. Go get yourself a pint, girl. Yeah, that's where the whiteboard really became famous. Yes. The painted paramedic. Oh, I never heard that one before. Hey, Debbie Blair. No, Zach, you pay for the pretty ladies. Who was it who was here from Canada that I just saw and I didn't miss? That's the one. Jackie Seidel. Hello. Welcome, Canada. The Commonwealth's theory of the case is that Cara and Anne had a tumultuous relationship. They had separated and filed for divorce. Cara had been arrested for assault and battery, and they had taken out mutual restraining orders. They had reconciled and lived together again, but they were still fighting. The night before Anne's death, they argued via phone calls and text messages about Cara's friend, Mike, visiting Cara at home while Anne were at work. The Commonwealth argued that after Anne returned home the morning, their fight continued, which culminated in Cara unaliving Anne. They argued that Cara then went shopping with Brianna to craft an alibi. When she returned home, she attempted to contaminate the scene by pouring paint on Anne's body and over the basement. The defense was that the police had failed to investigate at least two other suspects, Mark Olesak. Yeah, that's Mark the saxophone. And Carla Danielle. Olesak was Anne's friend, but also had a romantic relationship with her. He told her that he loved her. He opened credit cards in her name. He lied about his relationship with Anne to his wife. He lied to the police about where he was the day Anne died. He spoke to Anne on the phone the day she died, and he deleted his last text message to her from his phone. Danielle had been in a romantic relationship with Anne on and off for years. Danielle had allowed Anne to use a credit card with about $10,000 in debt. On the day of Anne's death, Danielle was seen at her gym. She left the gym to go on a run shortly after arriving. She made an ATM withdrawal while away from the gym. She also had a tanning appointment that day of Anne's death. The police recorded a small plastic cup next to Anne's body with the words BioGlow written on it. Oh yeah, BioGlow, that's the solarium tanning bed enhancer. The defense argued that each of the alternate suspects had motive to kill Anne. Additional facts are discussed in the body of the brief. Oh, you have the cream pie tank. Thank you so much. It's made well and good fit. Okay, I might just have gotten something that didn't... it can be a little bit hit and miss with these things. Talk about someone with motive of... old Smaximaphone had one and he was hiding an affair. Plus, he kept sleeping in her sleeping bag for months after. And he had given her a credit card without telling his wife, and I believe there was $25,000 in debt or something like that. He had all the motive. Plus, he had no alibi. I think he had a doctor's appointment in the morning, and then he was just home the rest of the day. Yeah, but trust me, bro. Hey, Carly. Cara Rintala was subject to a fourth trial 13 years after the unaliving of her wife, Anne Rintala. During impanelment, the prosecutor struck a 20-year-old woman from Spain, España. He claimed that he struck her because of her age, but this was pretextual. He did not strike a similarly situated male juror and admitted that he was using age to insulate his strike from Batson challenges. In the years before Cara's first trial, the case received significant media attention because of the two mistrials and her overturned conviction. The parties took care to shield the jury from the procedural history of the case. However, the jury learned during deliberations that Cara had been incarcerated for 5 years as a result of a prior trial. No instructions could cure the prejudice. This information eroded Cara's presumption of innocence and the Commonwealth's burden of proof. After the jury spent weeks hearing testimony about the gaps in the police investigation. Oh, this is also where I had my longest stream about nothing. I believe we were on verdict watch for 36 or 38 hours, and they swapped out jury members during deliberation, which I found absolutely crazy. They just sent me home and said, yeah, you go into the room and start over. That's right. After the jury spent weeks hearing testimony about the gaps in the police investigation regarding other suspects in Anne's death, the judge instructed them that they could not base their verdict on unanswered questions. But he also instructed the jury to consider whether those unanswered questions may have led to evidence of the defendant's guilt or innocence. This confused the jury. The judge should have included Cara's request clarifying language to harmonize the instructions and resolve this confusion. Argument. Juror 40, an accomplished college student, had an individual right to serve without being discriminated against based on her gender. The prosecutor struck her when he did not strike a male and admitted he was employing. We just read that. Relevant facts. Juror 40 raised her hand during general questioning. She explained it was because her cousin was a lawyer in Madrid, Spain. During individual questioning, she did not voice any concerns. When asked about her schedule as a college senior, she said that the trial schedule would be merely annoying, but it would not interfere with her studies. She was confident that she could manage jury service, and as a senior at Holyoke College, she had relaxed classes. She explained that her rigorous schedule in high school due to sports and advanced placement classes gave her experience managing other responsibilities along with academics. When discussing her parents' divorce, she stated that she knew that each experience is a unique, all of them. When the judge found her indifferent, the Commonwealth struck her from the jury. Cara raised a Batson Saurus. It doesn't say what that is, just case law. Challenge based on gender and race where only one other sitting juror identified as a woman. The judge found Cara had made a prima facie case. The prosecutor's justification focused on the juror's age and supposed lack of life experience. He asserted that his challenge was based primarily upon her age, and my study of the case law after yesterday's experience is that age is not a protected factor under Batson Saurus. In summing up, he stated, everything else about her, to be honest with you, I like. She seems very accomplished, very intelligent, but it's her age, and that is a non-discriminatory under Batson Saurus. Adequate justification for preemptory. Cara pointed out that the prosecutor did not strike Juror 9, a 23-year-old Hispanic male student who had been seated earlier that day. The judge ultimately allowed the Commonwealth strike, finding, I find that the explanation is genuine, that it's sincere, that it's the actual basis for the challenge. It seems like it was sort of two parts. One is sort of the age of the juror, but also the second part would be the course load and the fact that she was a double major and that all of this would be sort of happening at the same time. I personally don't agree that that would be a problem for her, but my job here is to assess whether the challenge is genuine and adequate, and in this case, although I don't agree with it, it's personal. Although I don't agree with it, is personal to the juror. Interesting. BS prosecutors lied. We don't believe any prosecutors lies on this channel. This is a pro-prosecution channel. Special pro sector Brennan is my favorite. Oh, she's not going to prison. She is in prison. Two of the prosecutor's final three peremptory challenges were against women. First, the prosecutor challenged a white woman. This was the prosecutor's first peremptory strike after Juror 40 was excused. The defense objected because the prosecutor was striking a female juror. The judge dismissed the juror. Next, the prosecutor struck Juror 17, a black woman. At least they are equally against women. The defense objected that the strike violated Batson based on race, gender, and LGBTQ status. The judge disallowed the strike, finding that the prosecutor's reasons were adequate but not genuine because the prosecutor was relying on the juror's media exposure, when the prosecutor also seemed to credit the juror's response that she could put her knowledge from the media out of consideration. And then we have the relevant law. The 14th Amendment, Equal Protection Clause, forbids the exercise of peremptory challenges on the basis of gender. Article 12 similarly entitled both defendant and jurors to a jury drawn free from discrimination based on gender. Jurors have an individual right not to be discriminated against because of gender, regardless of how other jurors were treated. Discrete instances of invidious discrimination violate the constitutional right of the defendant and the juror, regardless of the jury's composition. Once a Batson challenge is raised, the resulting three-step inquiry is familiar. First, there must be a prima facie case, merely a reasonable inference of discrimination. Second, the prosecution and not the judge must give a neutral explanation for the challenge. To be adequate at step 2, the neutral explanation must be specific, personal to the juror, and related to the case. Third, the trial judge must determine whether the prosecutor's stated reasons were the actual reasons or instead were a pretext for discrimination. A perfectly reasonable explanation must be rejected if the judge does not believe that it reflects the challenging party's actual thinking. To fulfill Batson's promise, a reviewing court must consider all the relevant circumstances and not accept the prosecutor's explanation at face value. The overall context here requires skepticism of the state strike. The court reviews the judge's step 3 factual findings for abuse of discretion. There's an abuse of discretion when a decision results from a clear error of judgment in weighing the factors relevant to the decision, such that the decision falls outside the range of reasonable alternatives. Juror comparison. The judge erred in allowing the prosecutor's preemptory strike of juror 40 because the prosecutor's stated reasons were not genuine. The prosecutor claimed that he exercised the strike because of the juror's age and alleged lack of life experience. His reasons do not survive juror comparison. More powerful than these bare statistics, however, are side-by-side comparisons of some black veneer panelists who were struck and white panelists allowed to serve. This is an old law, if they can call it that, I think. The prosecutor did not challenge juror 9, a 23-year-old Hispanic male college student, yet challenged juror 40th, a 20-year-old female college student born in Spain. The primary difference between juror 40 and juror 9 was their gender. Implicit bias can play a significant role in a prosecutor's decision to strike a juror. The typical woman is seen as nice but incompetent. The typical man is competent but maybe not so nice. These stereotypes mean that people may like women more than men but may not necessarily respect them. Susan T. Fisk, Stereotyping, Prejudice, and Discrimination. I don't know if I believe in that. Jamie is not nice. Juror 9 was in graduate school and advised undergraduate students who intended to go to medical school. He also worked part-time as a soccer coach at a local high school. When the judge raised the juror's schedule as a potential problem, the juror indicated that he had a reduced workload at school and the trial schedule would only impact the coaching to a small degree. The Commonwealth also consistently asked jurors about their relationship with people in the medical field. Juror 40 and Juror 9 had close relationships with people in the medical field. The Commonwealth did not raise any concerns about this with Juror 9. When Cara objected to the strike of Juror 40th, the Commonwealth called the comparison between 9 and 40 apples and oranges. The assertion does not survive a comparative juror analysis. Juror 9 was only 3 years older than Juror 40th. Like Juror 9, Juror 40 was a standout scholar and athlete. They both were mature for their age. They both did not raise the trial schedule as a concern. Juror 40 negotiated an international move with success, and she experienced a divorce and yet was able to express a very nuanced view on the topic. This is hardly the immature individual that the prosecutor claimed he was screening for. Commonwealth v. Jones. It was telling that the prosecutor did not strike prospective jurors with similar characteristics at juror who was struck. 2. The prosecutor's reliance on age as the reason for the preemptory strike was pretext for discrimination. Here, age was not a genuine reason for striking Juror 40. It was a pretext. After having a previous strike rejected, the prosecutor clearly signaled that he intended to use age to insulate his strikes from Batson objections. The Commonwealth's incessant pushback on the judge's initial findings of a prima facie case of discrimination the court the fact that I'm asking you for an explanation, or from the fact that it can be inferred that I find that there's sufficient basis for a prima facie case? Again, I'm going to ask you for an explanation. ADA Ganji, respectfully, what's the basis? The court, so this is not a cross-examination of me. What? That must have been some discussion between them. Where did that go? What? Number 9. Where's that footnote there? Coupled with the later statement regarding his knowledge that age is a permissible reason to strike a juror, demonstrate that the proffered reason to strike the juror was not genuine. Commonwealth v. Benoit. Wrestling fans know that name. Use of occupation as reasons to strike a juror must be carefully scrutinized when a party's use of peremptory is challenged as discriminatory. Jury 40 did not hesitate on her answers throughout questioning. Even when the judge expressed concern for a school schedule, she admitted that it was a burden like any jury would have, but the commitment would not interfere with her studies. The Commonwealth claimed that the juror's age meant that she did not have the life experience that forms a rich foundation for a juror's perspective in a murder prosecution. Yet he also called her accomplished and intelligent. The juror explained that her parents had been divorced and that she had experienced enough of life to know that each experience is unique, all of them. She also discussed her time as a high school athlete and the commitment and dedication it took to be successful in the sport and her academics. She had lived in multiple cities, indeed multiple countries, each situation with its own experience. The prosecutors claimed that the juror was too young and supposedly lacking perspective was pretextual. Because age is not a discrete protected group for the purpose of Batson, Commonwealth v. Greer, it has become a pretextual crutch for prosecutors, as in this case. Research has generally focused on Batson's effect on race-based challenges. A growing body of evidence shows that Batson has done very little to make juries more diverse or prevent prosecutors from exercising race-based challenges. However, it follows that the Batson framework has also failed to protect potential jurors from gender-based strikes. It has become a pretextual crutch for prosecutors in the case. Nancy S. Marder, what does prosecutors think about Batson? Prosecutors were concerned their colleagues were striking jurors based on proxies for race. Race, gender, and age are the most physical perceptible characteristics and therefore the most likely to trigger stereotypes. As such, the Batson framework has done little to eliminate discrimination in jury selection and is instead incentivizing parties to create ways to obscure that discriminatory intent. See Equal Justice Initiative, Race and the Jury, Illegal Racial Discrimination on Jury Selection. The Batson decision did not deter prosecutors from engaging in illegal race-based peremptory strikes as so much as incentivized them to find ways to keep striking black jurors without triggering a Batson objection. Once a party has raised an inference of discrimination at step 1, the judge must require a step 2 reason, as happened here. But at step 3, judge must evaluate that reason from a place of skepticism because the research indicates prosecutors may use any reason as pretext. Having made these observations, we now consider the charade that has become the Batson process. The state may provide the trial court with a series of pat race-neutral reasons for exercise of peremptory challenges. Since reviewing courts examined only the record, we wonder if the reason can be given without a smile. Surely new prosecutors are given a manual, probably entitled Handy Race-Neutral Explanations or 20 times tested race-neutral explanations. It might include too old, too young, divorced, long, unkept hair, freelance writer, religion, social worker, renter, lack of family contact, attempting to make eye contact with defendant, lived in an area consisting predominantly of apartment complexes, single, overeducated, lack of maturity, improper demeanor, unemployed, improper attire, juror lived alone, misspelled place of employment, living with girlfriend, unemployed spouse employed as school teacher, employment of part-time barber, friendship with city council member, failure to remove hat, lack of community ties. Children same age bracket as defendant, deceased father, and prospective jurors aren't receiving psychiatric care. Apparently, everything has been used to try and strike jurors. Kind of weird. That is what happened here. Significantly, the prosecutor twice stated that he was aware that age is a permissible reason to strike a juror. These statements made it plain that the prosecutor was using age as a time-tested pretext for discriminating against juror 40th. District attorney training materials combine practical tips from Batson case law with encyclopedias of stock court-approved neutral reasons and so-called proven strategies aimed at avoiding a finding in discrimination. The pretext for discrimination is particularly apparent where the prosecutor failed to ask any follow-up questions related to the reason that he ultimately relied on to strike the juror. Indeed, the judge explicitly disagreed with the prosecutor's reasoning, but still found the reason genuine. The judge's scrutiny at step 3 was too differential to protect juror 40's individual constitutional right to serve free from discrimination. Some group natural reasons should be scrutinized carefully. I don't know. Number 2. That was all about the discrimination about a juror because of her age, because this has probably been litigated a lot against racial bias. The text was a lot about racial bias, but it's because he claimed that I don't want that woman because of her age, but in reality, most likely because she was a woman who could be favorable of the defendant. Oh, not important. Sorry, I just got a message on Discord. That's not important. Jurors reported that they were aware that Cara had been incarcerated for 5 years as a result of a prior trial. This extraneous information diminished Cara's presumption of innocence and the Commonwealth's burden to prove guilt beyond a reasonable doubt. This created irredeemable prejudice. Cara is entitled to a new trial. Oh, I didn't. Jamie, Jamie's not here. This is interesting. The facts. After 2.5 days of deliberation, the jurors sent a note on Friday afternoon. The note read, "Jurors have become aware of an outcome of a past trial with Cara Rintala that came from a fellow juror. We as a group would like you to be aware of this. Some of the jury were not aware of this shared information. Thank you." Info was that Cara had been incarcerated for 5 years. The following Monday, the judge questioned jurors individually about the note. Oh, did we hear that in open court? I'm not sure. I can remember they had the hearing and then they chucked off a few members of the jury. But I'm not sure I remember. We knew that's the reason. There was hearings about them meeting people out there somewhere. Jamie, did we know that that's the reason why they sent the jurors home? No, I don't. Again, it's a year and a half ago, so I might be a little rusty on the details. But as Sue points out, that should probably have been a mistrial. So, but I'm thinking the judge gets the note and reads it before he reads it in open court. He probably didn't do it with this one. Interesting. No, I might be correct. And hey, Katerina. Info was that Cara had been incarcerated for 5 years. The following Monday, the foreperson disclosed that it was juror 15. Yeah, I can remember someone was a snitch, but didn't we heard something about someone talking to someone outside? The foreperson disclosed it was juror 15 in seat 11 who shared the information. Then juror 15, Kathy, was questioned. She asserted that she did not realize the information about incarceration was outside information. She believed everyone knew about Cara's imprisonment because it had been reported in the media for years. Kathy identified another juror, Lenny, who also knew about Cara's incarceration. Kathy indicated that she could be fair and impartial and would disregard the information about incarceration. The judge did not credit the juror's answer and found she could not be fair and impartial. The judge stated, although Kathy had said that she can be fair and impartial, I don't credit that. She indicated that this was something that was part of her opinion of the case. It's clearly something that is improper for her to consider, and so for the reasons, again, nothing to do with the deliberations or her relationship to the jurors or views of the actual evidence in this case. I find that she cannot be fair and impartial. I'm going to excuse her. Yeah, so that's why they got chucked out in the middle of the case. Oh, well, now someone is mad at me. But I thought someone was traveling, but then we have to chuck her a link so she can come yell at me in person. But you can't put the toothpaste back in the tube. If they had given this information to the other jurors, they knew, and then they just went back and deliberated again like nothing had happened. Yeah, that's the whole jury is tainted from this. Yeah, if we had known that at that time, we probably would have lost our mind. Hey, Crispy. Yeah, that's... Yeah. Good morning. Jamie is about to come on screen and yell at me because I have got yelled at in Discord that I didn't send her a link because I thought, oh, Jamie is traveling. I know when I'm traveling, I like to take it slow, make sure everything is packed. I got OCD about traveling, so I'll check my bags like 25 times the last day, make sure I have my passport and stuff like that. So I thought maybe Jamie's doing the same, but I just got a message. Maybe you could invite me on so I can talk to you. I'm sorry, Jamie. Link is in DMs. Once you tell the whole jury is tainted. Good Lord, Commonwealth, you suck. P.S. This is why multiple trial get more and more difficult. Yes. You can't put the toothpaste back in the tube, but you can scoop out a little bit from the end and replace it with wasabi in one of your close buddy's toothpaste tube. So I have heard. It doesn't matter. Even if I have list and made the checklist, I will go through my bags multiple times. I have already packed for the weekend, and I will go check those when I'm done streaming. Yeah, it's like being in the room with Jamie when I do my Jamie voice. And I love that she said, you could send me a link, maybe. And then she doesn't come on. It's going to be 3 days where she just yells at me in person instead of online. I don't know how you said, I don't want to eat herring. Why did you buy me licorice? I don't want to do that. Can you take that camera away? Why don't you know the king? So, but I'm going to send her and Iris out frolicking with Penilla. I hate being late at the airport as well. Yeah, that's why I don't want to take it to a restaurant. So Valhalla makes sure we go to restaurants where I can't be served beer if I don't have my passport. I can't do that. Next, the judge questioned Lenny, juror 18 in seat 1. He indicated that something on the radio had caught his attention regarding the case, but claimed that he could be fair and impartial. Before deciding Lenny's ability to serve on the jury, the judge questioned the remaining jurors. When the judge returned to questioning Lenny, Lenny said that he had been exposed to some media about the case. The judge removed him and excused the jury for the day. The next day, defense counsel moved for a mistrial because the information of Cara's incarceration was too prejudicial to be ignored. The judge denied the motion. I remember that part. Well, I don't know any titled gentleman. I am farm stock. I don't know fancy people. Well, I do. Well, I don't know him. My dad was pretty good friends with the count who has the manor outside of my town. Argument. The Sixth Amendment to the United States and Article 12 of the Massachusetts Declaration of Right guarantee the defendant the right to a fair trial by an impartial jury. The introduction of extraneous information to jury deliberation violates the defendant's right to be tried only upon the evidence introduced at trial and to be tried by an impartial jury. Where extraneous prejudicial information taints even one juror, the right to a fair and impartial jury is violated. An extraneous matter is one that involves information not part of the evidence at trial and raises serious questions of possible prejudice. If there is reason to believe jurors were exposed to extraneous materials, judges must conduct a voir dire sufficient to determine whether there was indeed exposure and its prejudicial effect. If the judge has conducted an adequate inquiry, the resulting decision to deny a motion for mistrial based on extraneous information is reviewed for an abuse of discretion. In the 30 years since Camara, no defendant in a reported Massachusetts case has faced an extraneous influence as prejudicial and as destructive as a presumption of innocence, as all jurors learning of the defendant's incarceration as a result of the prior trial. See also Commonwealth v. Da Costa. Jury heard recorded statement of witness that somebody got shot down the street. Commonwealth v. Hart. Jurors heard racially charged joke by another juror. Commonwealth v. Blanchard. Jury exposed to judge's trial binder, which contained excluded evidence. Philbook juror discussed their feelings about the strength of the case as well as personal experience of being a firefighter. Commonwealth v. Amron. One juror exposed to 4 unredacted transcript pages from the defendant's police interview. Womack jurors expressed, "Hey Jamie, I missed you so much. I'm so happy to have you here, and I can't wait to meet you in person. It's going to be so nice to be hanging out with you."
It is. Don't pretend.
Sadly, there won't be any videos. The diva has ordered that we are not allowed to do videos.
I just said I don't want cameras in my face the whole time. Because we're gonna have fun. Are you okay?
Yeah, I was just. I've been reading. I've been reading 30 pages. You get a little.
Oh yeah. But no, I kind of like, as much as I like doing this, like when we're like having conversations and hanging out and stuff, like I just don't want cameras in my face.
No, I won't be doing the Dave thing.
Well, that's what I mean. Like that's all I imagine. It's like, and then you're just saying the stupidest stuff, and you know.
I'm thinking we're gonna set up the laptop, and I bought some candies for a tasting test.
Yeah.
Just how it was and how it is, and you're probably gonna need a nap and stuff like that when you check into the hotel. So, yeah.
Well, I don't mind if like we sit down and like do something like that. That's fine. But I just meant like when we're trying to like walk around and have conversations and do things, like just somebody waving a camera around the whole time is kind of like,
Yeah, and Pernilla is gonna tell us all the stuff she did, unspeakable stuff, because she's a Swede. They only do bad stuff.
it'll be fun.
And
Iris is
Mads is
already,
coming as well, so
yeah, it'll be
you'll
fun to
be
meet him
fluent
too.
in Danish before you're going home.
I doubt that, but I'll try. I'll sound ridiculous. We got to find some good souvenirs though. Like you got to
Well,
figure out
we can
where
get
to.
the crappy. I'm gonna take you down the main, what's called Strøget. That's a walking street with a lot of shops, all the fancy shops and all the touristy stuff. But we're also gonna go and see a lot of places, and you can figure out what you wanna. And remember to bring your camera and take a lot of pictures, because it's very, very different from American architecture. I can tell you that.
Oh yeah. I mean, I have to get some pictures of like little castles and architecture. Of course.
I hate when people visit and I forget English. We always joke with the people who have been exchange students, because they come home and speak Danish with an English accent, and we always joked about it. After doing this for 2.5 years, I do the stupid thing of slipping into English when I talk to my family, because you're talking about a case, and then because my daughter was asking me about the Karen Reed case, and then you just want to answer her, and oh yeah, the motion in limine, and I don't know what a motion in limine is in Danish, but why the heck am I answering my daughter in English? That's
I mean, do you guys actually just speak Danish to each other strictly or no?
why shouldn't I speak Danish to my? Do you speak Spanish to your parents?
I don't know because you speak English. I don't know what in your life, like where
I'm
you
Danish,
actually.
Jamie. Jamie, nice to meet you. We've been doing this for almost 3 years.
So you only speak English to your English friends? Is that pretty
I don't have
much?
friends, but I speak English online.
Well, you know what I mean. I don't.
So
I
no, I
you
don't
speak
go.
so.
I don't go to the gym and say, "Hey, everybody, I need a spotter. Can you come over here because Daddy got to move them titlets today?" I'll go down there and say, "Hej, er der nogen af jer, der lige kan komme over og give mig et spot, fordi patværket, det skal lige have en ordentlig rysttur i dag, du ved." They would look at me weird if I went around speaking English.
Well, I don't know. I guess because you guys speak so much English and you do, and I just see it that way. Like, is it strictly Danish everywhere, and then you just
Yeah,
speak English
we
here,
we
pretty much?
we are actually quite proud that we are less than 6 million people and we have our own language, which is
You
one of
make
the
it sound
oldest
so
languages in the
terrible.
world. Our
I'm not trying to
language
be
is
offensive.
the basis of English as well. A lot of the English words is derivative from Danish. If you go to Scotland, parts of Scotland, they have an accent that actually is quite Danish, because we used to go over there and say hello every summer.
Well, does everybody know English in your family?
Of course they do. We went to school, Jamie.
Okay.
How old were you when I learned English in? We started in 5th grade. My kids started in 3rd grade, and I think they start in 1st grade now. So is my family's English as good as mine? Well, mine is barely passable. Both my oldest brother and my sister has spent time as exchange students in Los Estados Unidos. My brother works in IT, and they talk. I don't understand it. I think they speak English, but everyone is taught English in school.
Hmm.
You normally learn English, German, and then a third foreign language, as we call it. So you're gonna take care of that one when she walks around in the streets and say, "Hey, we are Danish person. Why don't you speak English?"
I'll be the one running around going, "Hi, everybody."
Well, as my friend in Delaware, when she brought her husband, he was like, "Oh, I don't speak Danish." She said, "No problem." And he was surprised that everyone everywhere spoke English, except those weirdo trolls that works in Copenhagen. They speak Swedish. Don't forget my skilpad bars. I didn't
The
know we were
Skittle
getting
paddle.
skilpadder.
I don't know. She wanted to try some of the candy.
Oh.
You just got to send her a box of stuff. She deserves it.
I'm gonna
she's a
fill your backpack with candy.
I don't know if I have much space. I just realized I literally am taking just what I need, and my little baby suitcase is like full.
Yeah, I'm also just bringing a couple of things and then it's full.
Mhm.
Laptops and stuff like that fills a lot. But what do you think about the age discrimination against the female? That he used age as a way of discriminating against the female. I could see that.
Yeah.
But this is the reason why two of them got chucked at home. That's a big surprise for me, because we only heard that they were. Didn't they talk about someone had said something outside, and that's why they had to ask the questions?
I remember one of the reasons somebody got let go was like personal reasons, but they were very, it's just personal reasons. And that was like all they said to it that I
Yeah, but
remember.
there wasn't there like 2 or 3 times they were asking jurors question, or was it another trial? I just feel like there was 1 or 2. Yeah.
They sent a note, I think twice.
Yeah,
Remember?
but apparently we didn't get that note read to us, but the judge must have read it and said, "Nope, we are not doing this in open court," because he should have chucked the case on this basis.
Because wasn't this the one where he was bringing people into the chambers? Because I could have swore. I think so. To question them.
It's a year and a half ago, so I can't remember exactly every day. And we only did 38 hours of verdict watch. So if you arrive in the morning, stay outside all day, and you'll adapt fast. Sleep before 10 p.m. and you'll be tired all week.
Oh, I just got a message before I got on here that my flight is now an hour late. So now it's going to be 7:40 I leave.
Well, as long as you have time to catch a plane in Schiphol, that should be okay.
Yeah, because there's an hour 45 layover, so I should be fine.
Just get Helen to come pick you up at the airport and drive you up here.
Oh,
I don't know how far
Amsterdam?
Schiphol is from her. And Brandon says, "Don't misplace your ID, Jamie. Makes life hectic."
I hope I don't. I should be fine, hopefully.
Yeah, you don't need ID to buy stuff and stuff like. You can use your driver's license. That's no problem. So and we don't card people at bars because 16-year-old people buy beer here. So you don't have to bring all of that around with you.
Yeah, hopefully. Well, I'm just bringing it for the purposes of the airport, and then hopefully I never have to take it out again.
Take Jamie to Denmark Beer Fest. I don't know what Denmark Beer Fest is. Everything went to hell after my flight yesterday. They were shutting airports down, 5-hour delays. Thankfully, I refound my ID in time. Or I thought rebound. Yeah, Brandon was about to crash a plane yesterday. So.
Oh, Brandon.
Danish Beer Fest, is that a Tuborg or Carlsberg arrangement? Yeah. That's, I don't know. It's a secret club, Beer Fest. Never heard about it. And I have drank my amount of beer in my time on this planet. That's just case law. There's a full site. What? Defense incarceration and prior trial, and then it's just case law while they are showing as case law in this. Well, that doesn't make sense. Oh no, I didn't get all the case law they are putting in the footnotes. Where did we go? No. Jurors expressed concern over intimidated interactions with spectators in the courtroom. Juror looked up definition of reasonable doubt and brought copies to other jurors. Many should do that. Juror had animus with another deliberating juror. Juror recognized co-defendant and his family as her neighbors. Juror had been in contact with defendant for length of trial. Juror watched news program on the case. Judge conducted no inquiry until after deliberations. Only one juror learned of defendant's prior convictions. Defendant did not move to dismiss the juror. Juror expressed fear because of where she lived, and jurors had been filmed by a television camera and watched by unidentified men in the parking lot of the courthouse.
You're not sharing, are you?
Oh,
did you mean to
well,
share
I'm just reading for your pleasure, Jamie.
Okay.
While on a view, spectators shouted at jurors that defendant was a murderer. Jurors were followed from courtroom by spectators. Jurors conducted outside research related to cost and weight of drugs. Yeah, call it outside research. Friend of victim's sister called jurors home to ask how trial was going. And then I have to go back and read this. And juror expressed fear of defendant based of gang affiliation. Extraneous information related to gang affiliation or fear of the defendant is obviously salacious and requires inquiry of the jury. However, learning of the defendant's incarceration because of prior trial goes beyond salacious and inescapably erodes the defendant's presumption of innocence. The inference in the juror's mind is that a prior jury found the Commonwealth met their burden of proving Cara guilty beyond a reasonable doubt. Compare Commonwealth v. Drumgood. Unfair and improper inference may be drawn by the fact finder if a prior conviction admitted in evidence is substantially similar to the crime being tried. Emphasis in original. Here it is worse. The crime is not substantiated similar. It is the same crime. The parties and trial judge all recognize the importance of minimizing the prejudicial effect of reference to prior trials through voir dire questions, jury instructions, and careful testimony. There's trial scripts. During impanelment, several jurors disclosed knowledge of the case through the media. That's a lot of trial transcripts. During testimony, several witnesses referenced the prior trial. Then the jury learned over objection that Cara had been arrested for allegedly assaulting Anne. They were instructed that Cara's arrest for assault and battery was only evidence to show the tumultuous nature of the relationship, not a prior bad act. Well, bullshit. While Cara maintained that the evidence was prejudicial, it would not merit a mistrial standing alone. Commonwealth v. Lau, reference to prior proceedings and trial transcript did not entitle defendant to mistrial because there was no evidence defendant was in prison and defense counsel did not request curative instructions. However, once the jury learned during deliberations of Cara's 5-year incarceration as an outcome of a prior trial, the prejudice became irredeemable. Camara. The prejudice to the defendant is almost certain to be as great when that evidence reaches the jury through news accounts as when it is part of the prosecution's evidence. Marshall v. U.S. The information went far beyond the general speculation that there was a prior trial, which the parties had taken precaution against. It informed the jurors that Cara had been found guilty. See Commonwealth v. Kincaid. In post-verdict inquiry, flight of co-venture suggested defendant's guilt and was so prejudicial to the jury as to require mistrial. The jurors likely inferred that Cara had been found guilty of the same crime previously. Learning that Cara had been incarcerated for 5 years suggested to the jurors that a prior jury had found the defendant guilty, the outcome of the prior trial. This diminished both the jury's role as fact finders and the defendant's presumption of innocence because it created the inference that a prior jury had found Cara guilty beyond a reasonable doubt. Compare Commonwealth v. Delaney. Conviction reversed where instructions to juror on the role of the grand jury may have left the impression that grand jury had made its determination based on proof beyond a reasonable doubt, diminishing trial jurors' responsibility. Additionally, learning of the outcome of a prior trial and the defendant's incarceration is akin to but worse than seeing the defendants shackled during trial because it creates the presumption of guilt and dangerousness. See Deck v. Missouri. Rule forbidding use of shackles in court was meant to protect defendants appearing at trial before a jury. Oddly, that the jurors did not see Cara in shackles in passing made it worse. This crystallized that Cara's 5-year incarcerations were not just pre-trial detention on a serious charge. It was what the jurors said it was, a sentence imposed as the outcome of a prior trial for having committed the most serious violence one can commit. Massachusetts has a long history of restricting shackling of the defendant because these displays tend to create prejudice in the minds of the jury by suggesting that a defendant is a bad and dangerous person whose guilt may be virtually assumed. Commonwealth v. Brown. Here the information went beyond the inference of guilt. It made Cara's guilt inevitable. Given the exceptional history of this case, only 3 other defendants has gone to trial 4 times for the same charge in modern Commonwealth history. The cumulative prejudice effect of the extraneous information requires special scrutiny. How long is this part? Oh, it's not that long. There were unavoidable concerns such as the extent of the media coverage over the 13 years between Anne's death and Cara's 4th trial, the jurors' learning of Cara's incarceration after all other reference to the procedural history was the final prejudicial bill that could not be unwrong, despite the judge's individual questioning and attempt at curative instruction. See Jackson v. Deno, where jury was instructed to find whether the defendant's confession was voluntary. They could not be expected to ignore the nature of the confession if they found it involuntary. Despite the deliberating jurors' assertions that they could continue to be fair and impartial once they learned of Cara's incarceration due to a prior trial, the prejudice became too great. Defense counsel argued that the information seriously prejudiced Cara, calling it the elephant in the room when moving for a mistrial. The judge should have granted the mistrial. Turner v. Louisiana, reversing denial of mid-trial motion even after jury inquiry, potential prejudice too great. Whoosh, it's a long one. Baker, are you going to explain exchange rates and fees? I always try to maximize my dollar and lower my fees. I just go to a bank, put in my card, and withdraw money. Then they'll figure it out. I only trick I can tell you: never use an exchange office. Just you'll pay some fee if you use your card in. But I don't know how much. I just take it out the bank because as long as you take it out of the bank, there's not these crazy fees that you get. And never use an exchange office. They are always stealing money from you. In my opinion. Which is, I don't know anything. It's not monetary advice. But no, and you can just pay with your credit card. Thank you, Holly. Yeah, it was a little long. Yeah, exchange offices are really good when you want to get some clean money. Yeah, but I believe Jamie is. I know America is a little behind, but I think Jamie has a MasterCard or a Visa card or something. You'll just pay with that. And if you need a little money, go to the bank, withdraw money, and it'll cost a little bit, but it's not as expensive. It's not like the olden days where you had to travel with cash.
Yeah, I have a card. As long as I can use it, I'm good.
Yeah. We'll figure it out. It's not that big of a problem. Jamie's just gonna flash those lashes as some guy, and then she's living free all weekend.
Oh, jeez. No. If only it was that easy.
Oh. The trial defense hinged on creating reasonable doubt due to police investigative omissions. The judge probably instructed jurors that they could consider whether such omissions may have led to significant evidence of the defendant's guilt or innocence. But then the prosecutor and judge told the jurors they could not speculate without giving a requested instruction harmonizing the speculation instructions with the instruction of police omissions. This cut the heart out of the defense and confused the jury. The defense focused almost entirely on the omission in the police investigation. The Commonwealth objected to the defense closing argument and asked for a curative instruction, arguing that defense counsel had invited the jury to speculate on gaps in the evidence. The judge declined to give an instruction but reminded the parties that he would tell the jury not to engage in speculation and guesswork. The Commonwealth went on to argue in closing, your duty as jurors are to decide this case based upon the evidence that came in, and the judge will instruct you specifically on the concept in a little while. You are not to speculate. That's what they say in every trial. You are not to employ conjecture. The defendant objected that she did not invite the jury to speculate during closing. She zealously.
Where are you? Zealously
presented a potent defense. The defendant specifically requested the judge instruct the jury that considering the incomplete police investigation, it is not improper speculation. The judge declined and stated, I don't think a potent defense requires speculation on the part of the jury. It really goes to whether there's bias on the part of the investigators. It goes to whether the investigation is complete and therefore reliable. The judge ultimately read the standard instruction for omissions in police investigations. And now, a failure on the part of the Commonwealth to investigate certain witnesses, conduct scientific tests, or to otherwise follow standard procedures during the police investigation is a factor you may consider in evaluating the evidence presented in this case. Such a failure may create a reasonable doubt as to the defendant's guilt. With respect to this factor, you should consider three questions. First, whether the omitted test or other actions were standard procedure or steps that would have otherwise normally been taken under the circumstances. Second, whether the omitted test or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. Third, whether the evidence provides a reasonable and adequate explanation for the omission of these tests or other actions. If you find that any omissions in the investigations were significant and not adequately explained, you may consider whether the omissions tend to affect the quality or reliability of the evidence presented by the Commonwealth. In the alternative, you may consider whether the omission tend to show the existence of police bias against the defendant in conducting the investigation. All of these considerations involve factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances, which to me sounds like he's inviting them to speculate. The defense had wanted the following language in writing and orally to be read after the model instruction on omission in police investigation. I have instructed you elsewhere that your verdict may not be based on speculation. However, I instruct you that if you determine there were relevant omissions in the police investigation that bear upon your verdict, that would not be improper speculation. He also instructed the jury, you are not to decide this case on the basis of any guesswork, speculation, suspicion, or unanswered questions in your mind. You may not speculate as to what might or might not have been the facts. Defendants are permitted to elicit evidence of the inadequacy of the police investigation. The inference that may be drawn from an inadequate police investigation is that the evidence at trial may be inadequate and or unreliable because the police failed to conduct the scientific test or to pursue leads that reasonable police investigation would have conducted and investigated. And these tests or investigation reasonably may have led to significant evidence of the defendant's guilt or innocence. Commonwealth v. Silva Santiago. Defense counsel is entitled to argue that the jury should find the defendant not guilty because of the inadequacy of the police investigation. Arizona v. Youngblood. Commonwealth v. Fitzpatrick. The judge may not undercut the defense by instructing the jury to confine their consideration to the evidence that has been admitted. Commonwealth v. Remedor. Preserved instructional errors are reviewed for prejudicial error. Commonwealth v. Peruzzi. During the trial and closing, the defense focused entirely on the Bowden defense of inadequate police investigation into other subjects. Defense closing marshalling evidence of gaps in police investigation into other subjects. Before closing, the judge informed the parties that he would give the Bowden instruction to the jury. The Bowden instruction implicitly tells jurors that they may consider their unanswered questions to determine whether the omitted test or actions would reasonably have been expected to lead to a significant evidence of the defendant's guilt or innocence. The defense should have been able to rely on the Bowden instruction to inform the jury on how to shepherd the evidence of the omission in the police investigation. But the judge then instructed the jury that they could not base their decision on unanswered questions. The judge's instruction prohibiting speculation without any language to harmonize it with the Bowden instruction hopelessly confused the jury and unfairly deprived Cara of the benefit of the Bowden instruction. The SJC has recognized that such instruction can cause confusion and undercut the defense. In Commonwealth v. Alvarez, the defense properly highlighted the gaps in police investigation during closing. The judge did not give the Bowden instruction, but did instruct the jury that they could not engage in any guesswork about any unanswered questions. On those facts, the court found that the context in which the instruction were given would not have been constructed by the jury to undercut the defense's Bowden argument. The court reversed the conviction on other grounds and noted that in any retrial, if the judge chose not to give the Bowden instruction, it would be prudent to omit from the instruction the sentence, "You are not to engage in any guesswork about any unanswered questions that remain in your mind," to avoid the risk that the jury may interpret this sentence as undercutting the defendant's Bowden argument. The circumstances are worse here. Throughout the instructions, the judge told the jurors not to engage in speculation 6 times. But at the same time, the judge told the jurors to consider whether unanswered questions about the police investigation could have led to evidence about the defendant's guilt or innocence. The combination of these instructions confused the jurors about how to engage with the heart of the defense. Unanswered questions presented throughout a Bowden defense. See Commonwealth v. Puff. Juror confusion from model instruction. As such, the instruction were likely to have confused the juror and perhaps even misled them. Commonwealth v. Acevedo? I don't know. As in Alvarez, the Commonwealth v. Remedor, the judge did not give a Bowden instruction. Defense counsel was permitted to argue the gaps in evidence during closing. During deliberation, juror asked a question. The judge responded to the question by telling the jurors to confine themselves to the evidence presented at trial. The court found that this instruction undercut the Bowden defense because by allowing counsel to argue the failures of police in closing, the judge induced counsel to rely heavily on the investigative failures as a basis for the jury to conclude that there were reasonable doubt, and instructing the jury to confine themselves to the evidence admitted at trial steered the jury away from the investigative omissions. Here, defense counsel relied on the judge's decision to give the Bowden instruction and argued there were too many unanswered questions to find the defendant guilty beyond a reasonable doubt. The defense specifically requested language to clarify how the jury could consider those unanswered questions during deliberations. The prosecutor responded by arguing in closing that the jurors would be instructed to not speculate and focus on the evidence that was actually admitted. Commonwealth v. Heat, prosecutor's statements in closing not to speculate, coupled with standard instructions on speculation, had the potential to substantially confuse jurors about missing evidence. By failing to give the clarifying language, the instructions as a whole steered the jury away from considering their omission in the police investigation and undercut the entire defense. Instructions run risk the jury may interpret this sentence as undercutting in the defendant's Boughton argument. The combination of the jury instructions, the unusual procedural circumstances of this case, and the prosecutor's arguments about speculation confused the jury and combined to create error that went to the heart of the case. The conviction should be reversed. Conclusion: for these reasons, Cara's conviction should be reversed. That was a long one.
Good job. I don't know how you read that much in one sitting.
Well, it's only 43 pages this time.
Yeah.
That's why I stopped following the Baldoni case, because it was 177 pages, and I said, no way. This has taken me an hour, 1.5 hours. So I'm not gonna go read twice as much, 3 times as much. Talk.
Oh. Yeah. So how's everybody doing today? I'm packed. I think I'm good. I checked it I've been up since 5:30-ish, 6 this morning, because it's just when I normally wake up. But yeah, I mean, I packed last night, but then I realized I think I packed too much. So I started going through it and just narrowing it down to stuff that I actually need. Sometimes I'm just well, I might need this, I might need that. And yeah, I'm the worst.
I'm having a fisherman's friend.
Oh, good. Do those really work? Because I swear I've taken them before and they don't really do anything.
Well, it's not to clear your throat. It's just to give you a little. It's the licorice one, of course. Yeah, I don't know why I have a glazed donut as my avatar. What, if any, could that allude to?
Yeah. What if anything?
I don't know if the argument about the juror's age is going to change anything, but I actually think that the last 2 ones are pretty good arguments.
Mm-hmm.
That could you imagine her getting a 5th trial?
This poor woman, when I actually think that they had nothing to prove any of her guilt.
There was nothing. There was so much reasonable doubt. They never looked into those 2 weirdos.
Yeah, all this weird stuff that other woman had going on, and they didn't even. And then the lead investigator getting in trouble, and he didn't even come and testify. I mean, this is so sketchy.
Yeah, I forgot that the lead investigator. Yeah, and they couldn't mention he was a bad guy.
Yeah.
Yeah, it's a weird. I hope she gets a new case and she's gonna go home to her daughter.
Yeah, that's what's terrible about it. It's 13 years of this, 4 trials.
Yeah.
I mean, they couldn't even get a true conviction. This is the only time out of all those.
And they had to go down and put in so many potential options for them that.
Yeah, all the lesser included, and then she didn't even get what they wanted. They wanted her on a 1st degree, and it's they couldn't even get that.
It's voluntary.
For me, that's throw it out. Yeah, throw it out. This is insane. I don't think this jury honestly knew what involuntary manslaughter was.
It was just, we're gonna give her something. That's the feeling we had when we were done with those 36 hours. We're gonna give her something. Giving a kiss and drawing, a corner kiss. because he was only allowed to kiss her on the corner of the mouth.
That was his for giving her money, buying her gifts.
Yeah, and if he got her an iPad, he was allowed to smooch her right on the face.
Yeah, full on.
Mark Lacola saxophone.
I forgot about that. Mark Lacola saxophone. What was his real name? I don't even remember his real name.
It said somewhere. Mark. I can't remember.
So, and what was the cooking penis thing? Remember that?
Yeah, a cooking peen.
Cook.
I can't remember why.
You lost it because it came up on the
CC
captions. We were like, you paused. You're like, did you see that? Mark. Oh, it's Mark. Yeah. Oh my God, I love her. She had the best Boston accent.
Nothing's live today. Well, Tommy is live because Aiden is back in court today. Some old political crap. Well, Mo is also live. Baker is always doing a good live stream. Debatable. Besides Recovery Addict. I'm not besides Recovery Addict. This is Jamie.
Yeah. I'm usually not here. I know everybody misses me.
This case had a lot of good Baker clips. Yeah, there was a lot of whiteboard back then. My inspiration. I was a young man, Jamie. I had a lot of energy. I did a lot of drawings in that case.
Well, it was a good case. Like, I don't know. Like, there's a lot of. It was interesting. Even when the boring stuff came up, it was interesting because, like, going through all those like crime scene photos and stuff, and we were like, "Are you kidding me?" Like.
Yeah, we saw all the crime scene photos. We saw all the paint. We heard all about, it could be blood, but it could also be cleaning supplies. Yeah, but we think it's blood.
Oh, the swipes, like the swipey, because they ruined everything by just spraying it with luminol before they tested anything. And they're like, hey, look, there's these swipe marks, and that could be cleaning up of blood. Did you test it? No. That's just our theory. And they're allowed to say that, and we were so mad.
Yeah, because cleaning supplies could also kick out that reaction in luminol. So it could just have been someone was cleaning, because remember that the height of the cleaning up was really weird, and there was no blood on the shelvings, and the shelvings weren't cleaned. It was such a weird crime scene.
Yeah,
enjoy your visit there.
Oh, what? Sorry.
Enjoy your visit, Rebecca, Jamie, and Irish. Well,
should be interesting.
They will be frolicking. But thank you for 16 months.
Yeah.
Yes, this is where the corner kiss came from, because this weirdo was only allowed to kiss her on the corner of the mouth, and then he slept in her sleeping bag for a year and a half.
Yeah, at the firehouse, because he was in love with her.
And
Mark saxophone. Mark Lacola saxophone.
And this is also the case where they went to a Burger King the day after and looked in the trash can, and on top of it was the evidence in the case. And then they brought it back to the crime scene to dry on some butcher paper. It's not even like
in the middle of the living room. In the middle of her living room.
And it's not like in the Karen Reed case where they at least claimed they did it in the evidence, outside of the evidence locker. They didn't lock it into the evidence locker, but they did clean it on some butcher paper. There were so many things where we just, what the hell's going on here? And
yeah, like they just had a grainy video of her going through a drive-through, and then she changed her kid's diaper, and they're just like, oh, we got to get these rags. She took these rags, and they didn't even match the ones under her sink, because they said they claimed that it matched the same ones under her sink. There was absolutely nothing on them. So that was the whole point. We were like, why? What does that have to do with anything? It's not like there's blood or paint or something on them that she was cleaning something up and then went to a McDonald's and threw them away.
Burger King.
well, whatever. She went to both, remember, but it was Burger King, yeah, that she ended up at.
Yeah, because she got the mac and cheese at Burger King for her
Yeah.
daughter. I think we had Flux on to talk about when she worked at a Burger King and said we had schedules. We had to clean these, empty these trash cans every 4 hours or something like that. But they
Yeah.
found it 18 hours later. They found it in a trash can on top
Yep,
of
right on top.
everything.
Just sitting on top. Do you love it, don't you, 80s? I know. You're a closet fan.
Look at Jamie's puppy. I can't see any puppy.
Behind me? Oh, no, she's running around.
Why is he against the University of Michigan?
Because he's a Buckeyes fan.
From the Ohio State University.
Yes.
Home of the Cornhuskers and the Buckeyes.
Goddamn Buckeyes.
Jamie, I have to get you into football or something so you can watch a real sport and not all of this pretend sport that you play in America.
I used to watch soccer a little bit, but I couldn't get into it.
No, because all American sports are ADHD sports. Oh, we ran for 2 seconds. We better cut to commercials.
Is that what it is? I don't like it because too much is going on at all times.
It's because there's no breaks where you can, I can go frolic for the next 15 minutes because we're going to talk about erectile dysfunction and women's stomach yogurts.
The poop yogurt,
Yeah.
you mean? Yeah.
No Karen Reed today. It's been continued till the 17th and 18th, I believe it is. Another weird factor, the wife of the cop ex-girlfriend allegedly unalived herself with the cop lady Pew Pew. I didn't know one of them was a cop.
Wait. The wife of the cop?
The cop ex-girlfriend must be the one who was at the gym. Then. No, she wasn't. She was a businesswoman or something.
Yeah.
Did I miss something?
I don't know. Rusty, be more specific. Sorry.
Yeah. But yeah, both alibis. What was the alibi of Mark Lacola saxophone? I was at the doctor's at 9 in the morning, and then I was at home.
Well, no, he went to Walmart to get new pants, remember?
No, he drove to another city to get a new pair of pants, but that was in the evening. He was at the doctor's in the morning, then he didn't do anything, and then he went to get a new pair of pants at Walmart.
Yeah.
In another city.
Okay. We were like, that's not weird or anything.
As far as the Snoop Squad says, there won't be anything tomorrow. No. That the latest from the Snoop Squad is nothing mañana. That's tomorrow in Spanish, Jimmy.
Thank you. What's tomorrow in Danish?
I morgen.
I morgen. That's easy.
Yeah.
See? That's an easy word. I won't remember it.
You can speak Danish. And then you just have to say en ristet med det hele.
En mester.
En ristet. En ristet.
En restful?
En ristet.
En rested.
Med.
Mel.
Det.
Det.
Hele.
Healer. What does that mean?
A roasted hot dog with everything.
God. You're going to have to order it for me.
Well, I don't
Because
want
they're just
onions.
they think I'm crazy. Well, no. Are they raw onions or are they fried onions? There's a difference.
Yes.
Well, what's the yes? Guess what?
You get both.
Well, I don't like raw onions.
Well,
But I don't mind fried onions.
you're traveling. I ate moon pie. I ate deep fried
Well,
tomato.
you wanted to. I
No, I
know
didn't
already.
want to. someone gave me the eyes and said, "This is my favorite snack," and I thought, "Oh, she's allowing me to stay at her house. I better eat it." And I like Twinkies better.
Well, that's different because you didn't know you didn't like it until you ate it. Like I already know raw onions are not my thing anywhere, any shape or form. So, but I want to enjoy the sausage. So, come on. Oh, quit it. You know what I meant.
Danielle was Anne's ex-girlfriend. Well, she was her on and off again ex-friend. She was a cop. Oh, I didn't. I thought she was some kind of business lady, but it's been a long
Yeah.
time. And she unalived herself with Carla's police issue. She had that weird alibi too. Well, I went to the gym and put my stuff there. Then I went out for a run, and then I
Yeah,
went to a
she
tanning
logged into
salon
the gym
and straight out
to get
again.
her stuff and then went for a jog around the neighborhood. It was like, okay.
Yeah, she was going for 90 minutes, and she had an appointment at a tanning salon, and they found that cup of tanning oil at the scene. So
Yeah,
there was so many weird things.
very weird. You listen, Sean.
Hair ring,
I
hair ring, hair ring,
no,
hair ring.
I
Hair
don't mind
ring.
trying new stuff that I've never tried, but if it's something I just know that I don't like already, I don't want to be a brat
Ring, hair ring, hair ring.
because then I'll have to like flick them off. And then I look like even more of a dork.
I will,
Herring, no. Fish, please leave fish alone with me. I
but it
can't do
doesn't
seafood.
taste fishy. It tastes of the brine. It's kind of like everyone said yesterday that I should try corned beef, which we just call blown up ox in Denmark, but don't worry about it. So you should try the brine. It's the same. It's just a herring mash, a herring, corn herring. That's what I tried to say.
All right. I think you just want to get me on video and make fun of me for dry heaving. 'Cause that's what's probably going to happen.
Oh, she did it while she was in the shower, allegedly. Yeah,
Oh.
I remember they broke down the door with that snow shovel that they couldn't. They found her DNA on. Oh, so you found the homeowner's DNA on a snow shovel?
Yeah, on the handle. Okay.
Yeah,
That she used.
I love
I
raw
don't, yeah.
onions. This is war, and Michigan sucks.
No, Brandon.
Brandon is fighting Irish,
Yeah.
and he's also an alma mater of Notre Dame.
And does he know how I feel about them?
You hate them. You hate every other team in the world.
I really don't. The Bucks and the Fighting Irish are, yeah. What is it? Yeah.
It's Jamie is a hater. Jamie in
You have a lot of room to talk, sir.
in less than 12 hours. No, in less than 24 hours, we will be seeing each other in
You'll be
Copenhagen.
crazy.
I'll be catching a train in. I'll be catching a train at 9, and I'll be leaving my house in 13 hours. Yeah, in 13 hours, I'll be kicking off. You will be in the air at that time, halfway across the Atlantic.
Oh, I'm so nervous.
No, don't be. If you fall down, they'll never find you because there's just water everywhere.
Don't say that. Why does everybody want to say that?
That's just you can get over the counter sleeping help. Take 2 of those and just get some sleep after. They'll serve you food, put in your earplugs, and just try and get some sleep. And then when you arrive in Schiphol, you'll say, I'm in Holland. Isn't it weird? And you'll buy a pair of souvenir clocks and run to your next plane. And then at 11ish, you will be in Copenhagen. And then Iris will, if she passes immigration, she's probably have something in her bag.
She's already in England, so somebody let her in.
Yeah, but they're kind of weird. England is now making a law that people of non-English background apparently should be getting less for the same crime than as English natives, which I find is kind of weird. A two-tier justice system, but everything is weird in Europe. And then at 11:30 ish, I'll pick you up outside of the hallway and then take you into Copenhagen and find your hotel. And where your hotel is now kind of a hot place, but used to be the red light districts.
Oh, really?
When I lived in Copenhagen and you drove in that neighborhood, you could see parked cars swaying and streetwalkers.
Oh,
Now it's a fancy place.
Yeah, like I like flying, but I've only flown around the U.S. and I think the longest flight I ever was on was like a 4 hour, and for me that was good enough because I start to get stiff and like I think that's what I don't like.
That's why I'm saying if you can get some sleeping aid, try and sleep through it. That's the best way to, because especially with the red eye, it's just torture. I slept 1 hour the last time, and I had such a long wait in England. I was done when I get home. Buy Iris a cocktail for her birthday tomorrow. She'll just pour that weird stuff in it and give her lots of birthday spankings. I will not do that. I won't be Me Too by an American.
You better give her birthday spankings. Give her a birthday slap.
Oh, just
Exactly. With the sandal.
We can still take. I'm going to show them. I'm going to show them that side of the train station as well. We need to look at that.
Like
Because,
sketchy people? Is that where you're going to take us?
well, it's not that sketchy. I'm not going to take you to the bad part of Copenhagen. That's well.
I mean, I'll check it out as long as. Yeah,
I don't think we're going to go across Queen Louise's Bridge. That's where the really sketchy part starts now. But we'll go in that area because they have a big food market. So we can go look at that. Melatonin. Nobody dreams of playing minor league baseball. Benzos and booze.
Mm-hmm. What's the temperature like right now?
Benzos is just a little hard to get. Well, Jamie is a doctor. She can prescribe it to herself.
I wish.
How good's the tequila in Copenhagen? I don't know. I don't drink tequila. It tastes like sour milk.
I love tequila.
Yeah, well, you and Iris will have a fun time, and I will be the one saying I don't know them.
Yeah.
Yeah, it's not a dangerous area, but it's just where if you have a slight inclination for some Afghan product or some Colombian product, it's a good place to get it.
Oh.
And there's an asylum for men, or not an asylum, like a homeless shelter for men, and the Church of Mary is I don't know. Last time I was down, it's a street called Eastergade. Last time I was walked down there, the streetwalkers were standing at that church. But you can also buy a little powder and whatever you need.
You gonna get some?
No, I don't do that, Jamie.
Yeah.
As I said on some CPU's channel, I don't do drugs. I just like the smell of them.
Makes sense.
Well,
so Mass is coming to meet us too?
I think so, because he asked when we were going to meet. So,
is he going to be riding his bike? I heard about this bike.
What bike?
The bike he has.
I don't
They
know what
told
bike
me.
he has.
Am I crazy? Yes.
Yeah,
Your bike?
I don't know what bike he has. Is Denmark cool to Americans? Well, it's 10 degrees. Jamie will love it, but Iris will freeze her titlets off.
Oh, what's the temperature like right now?
10 degrees. So it's
It's like Fahrenheit?
no real weather. It's supposed to be over the weekend. It's going to be 51, 52, 46, 45.
Yeah, that's my
So
kind of weather.
it's hoodie weather.
Yep, that's
And
all I have. I'm just bringing my
looks like
fleece jacket.
overcast, no rain. So that's perfect weather for out walking. Think she tried to
Yeah.
land on autopilot too, was just pitching up and down, or she wasn't strong enough to control it. Either way, I thought everyone was going to projectile. I hate it when they can, especially if you're flying in a smaller plane and they have to go in and aboard. And that's
Mhm.
what I don't like, when you approach your landing and they just start swaying and you can feel how it just moves across the. I don't like that.
Yep, that's the puppy. I miss her already. Look at her.
Why? It's right behind you.
I know, but I know the minute I leave, I'm gonna cry
Then put some batteries in your cameras and get an app and you can watch it on the phone.
inside. Well, I did get batteries in my cameras outside, so now they're all up and running, so I can creep on my house while I'm gone. Not like anybody's gonna come over here except my sister.
Are people snobby towards Yanks in Denmark? No, it's Copenhagen. Copenhagen is our main city. It's an international city. We have tons of Americans working in Denmark, and the people we are most annoyed by is the Swedish. So as long as there's a Swede around, they'll be cool with Americans. And we're bringing our own Swede, so we have someone to. And if we get in trouble, we just push her in front and say she's Swedish. People will
Mhm.
get together, take her to the nearest town square, start throwing stuff at her. We're allowed to do that in Denmark.
You're terrible.
No, it's the truth. It's the
Well,
law in Denmark that if you want, you can throw rotten fruit at a Swede.
um, see, Mass said that was his bike. When you and Dave and Mass were together
I
in
didn't see his bike.
August,
I
was it
met
back in
him
August?
at a museum, so I
Oh,
didn't see any bike.
well, I didn't know if you were over there because Dave was taping it. You know how he
Yeah,
does.
we. The only time I really think I had really bad turbulence was I got woken up by it on the way home from the US last year. The ones where you just feel like the bottom is falling out. But I've been lucky with turbulence. It's just a little shakety shakes
Mhm.
I've been through.
Yeah, I've never had just a little bit, but nothing crazy. I mean, I think it's like a little over 7 hours from here to Amsterdam, and
Yeah,
then I got it, and then
an hour and a
it
half
said
from Amsterdam to us.
hour 45-minute layover, but now it's since I'm they're cutting off about an hour and 20 minutes of my flight's delayed. Should be okay, right? I mean, I'm sure
You're gonna be running through Schiphol.
it'll be fine. Yeah, is that's this thing. I hope it's not. Well, yeah, I hope it's not like too far from where I gotta go.
Well, I'm going through O'Hare when I come the next time. It's that's a big airport, and I don't have that. I have like an hour and 40 as well, so we don't need much headwind. Then I can't make it if I have to go to another terminal or something. I flew over the Arctic from Alaska to Germany. That was the most terrifying flight I've ever experienced. Yeah, I could bet the weather up there must be hell. Oh,
No,
were you flying
that'd
something
be
real or
scary.
a C-130? because we were supposed to fly into the Faroe Islands to play music back then, but they had delayed because we had a military plane crash up there. So and we had to go with the C-130, and I didn't feel like they want to send us up there. So
Hmm.
when I went through Schiphol the last time, they lost my baggage, but we got delayed 2 hours out of Copenhagen, and then I ran from the plane and directly onto the next plane to Switzerland, and they closed the door behind me. So that's why they lost my luggage.
Is Schiphol the one in Amsterdam that you're talking about?
Yeah.
Hopefully it'll be fine.
It'll be
planning
fine,
on
Jamie.
planning on carrying on my bag so I can just grab
In
it. and go.
24 hours, you're waking up after your afternoon nap and you're saying, Irish, let's get out there and celebrate your birthday with Five Guys. And I'm not talking about the fast food restaurant.
My goodness. I don't know if I'll be able to sleep at all. I'm gonna be
Why shouldn't you be
so
able to sleep? Just go
I
to
don't
bed and close
know.
your eyes.
Maybe I will. I don't know how I've tried to sleep on a plane before and it doesn't work out for me very well.
No, that's why I'm saying you need a nap when you arrive.
Well, I'm like a 5-year-old and I always want to know what's going on and looking out the window. I don't even know if I have a window seat. I don't even know where I'm sitting. I remember when I had to check in, I had to look and I was laughing because I had said, this plane can't be full, you know? I mean, who's really going from Detroit to Denmark at this time of year? But it
They go
looks like
to
it's a
Amsterdam.
well, Amsterdam, whatever.
Amsterdam is a pretty big hub for KLM. That's in. Oh, what alliance are they in? I can't remember what name that alliance had, but I think that's Delta, KLM Delta, and Swissair. I can't remember who is working together, but yeah.
Yeah.
Brandon says, I had planes get hit by lightning, lose power, drop a few thousand feet in an air pocket, near crashes, everything but the ultimate failure. You'll be fine, Jamie.
Okay. I know it'll be fine. I think it's just it's not that I'm scared of flying at all. It's just like I'm not looking forward to being like stuck in a plane for over almost 8 hours.
Where are you flying Monkey?
Monkey,
Yeah, that's what we call economy. That's
I
Monkey
guess.
class.
Yeah, I think normal. Yeah.
Yeah. Where you situated? Window side?
It doesn't say.
You
I
haven't
didn't
checked
pick.
in?
Yeah, I checked in, but it doesn't. It doesn't seat assign you.
No, normally it does when you check in.
Well, I didn't see anything.
I don't know, but yeah, because I've already checked, already assigned my seats for the trip home from Knoxville, but I couldn't assign them on the trip over because that makes sense.
Yeah. Well, I've never. I don't think I've ever done that before when I've flown. Like it just gives you a random.
Yeah, but you normally fly Spirit and stuff like that, so that's probably why they just as long as you have something that used to be a seat, it's fine. Hold on to this strap.
Well, that's what I said. I said I shouldn't even be worried because I used to fly Spirit so much when I would visit my friend in Florida, especially. And those planes were so janky.
I pay the money and upgrade your seat. Well, it gets expensive when because that's the problem I had last time. I upgraded my seat and to get the extra leg room, and you can only do it on the transatlantic flight. I couldn't do it on the flight to Knoxville, so I would still sit in the tuna can and just sit there and feel like a little fish. But I upgraded the last time, and I ended up paying 8,500 Danish for extra leg room, which I didn't have a seat in front of me, so my entertainment was on a fold-out table, and I had another fold-out table too. It was just a horrible, and because there was no seat in front of me, there was just the aisle. So every time they
Mhm.
brought the beverage wagon and that past me because you're flailing around when you're trying to sleep. So they ran into me. This time I bought premium economy, and I pay 900 Danish less for it. So I get a wider seat and more leg room
Did they
and
smack
priority
you with the
writing.
cart?
Yeah, it was really annoying because I paid like, I think I paid close to 1,000 Danish to upgrade my seat to get the extra leg room so I could stretch, and they woke me up 25 times. I was so annoying.
I mean, I might look. I mean, I don't know if it's possible to see what it is. It's not that much.
Yeah, yeah, and the other thing, you can't put your carry-on under the seat in front of you. You have to have it up top, so if you need anything, you have to stand up, and it was just that's why I said, F it. I'll pay the upgrade to premium monkey class, and it ended up being cheaper than the last time. So can't complain. So I'm getting like 2 inches more, and you ladies know how much 2 inches mean.
That can mean a lot. Yeah, and like I've never been on a flight with like fancy amenities either.
I thought we sent super chats to a seat upgrade fund. Where'd that money go? I did upgrade my seat. I just got it cheap.
Yeah, Baker did. Yeah.
Yeah.
Yeah, because he kept talking about it. He's gonna go big or go home.
I have spent
I know you get like food and like there's a TV on the seat to watch things and you get Wi-Fi and I was like, this is
oh, you
fancy.
get Wi-Fi?
That's what it says, free Wi-Fi.
Oh. Yeah, but it's probably just for texting. It's not for so you can peruse YouTube.
Yeah.
I did spend $1,200 on my tickets, so I didn't just take all the money and put it into Smex toys. Oh, I wish
think
I had the money to fly first class, but that's more than 10 times the price of what I'm paying now. My brother-in-law's brother works for a big toy manufacturer, and he had, because they had a little problem with some maybe potential harmful stuff that was in those toys. So he had spent a lot of time flying between Europe and the States and talking to Congress. But because he flew so much, he just racked up frequent flyer miles, and he said, "Okay, honey, we're going on a trip, and I'm going to upgrade." Normally he flew business, but he bought the big first class experience with all the bells and whistles, and he said, "I would rather fly business." So not everything is as it's cracked up to be.
Yeah. Yeah, I was gonna go on. I think I have a Prime account. I'm gonna see if I can download some stuff just to because I can download stuff from YouTube too, so I don't need.
Jamie, what company are you flying with? Delta?
Delta.
See, I know the Star Alliances. Let's go Delta and then say travel info. Onboard experience. Do they have the in-flight entertainment? Because Jamie, there's a thing called the internets. You can look at things on it, and one of the things you can look at is you can go in here and see in-flight entertainment, in-flight movies.
Oh, will it tell you? I didn't know that.
These are the ones. These are old ones. Oh, you can watch Gladiator too. Heard it's horrible. Hot Fuzz. Oh, I'm not showing it to you. Hot Fuzz is a great movie if you haven't seen that. Life of Pi. Hate it. That's so overrated. Moana 2. Mufasa. Big failure. But so you can watch. Oh, your favorite movie, Scooby Doo. The Gentleman. Great movie. You should watch that one. Oh, your favorite movie, The Sisterhood of the Traveling Pants. But these should be movies that you can see on your plane. If you don't want to see movies, you can also see a few TV shows. Because they have Paramount Plus on there. They probably only have like 3 episodes of each series, but still.
That's interesting. See, I've never been on a flight where they do stuff like this.
No, it's because it's international. You don't need to download anything. Everything will be. You will have enough to do. Just you will get a pair of really bad earplugs. Bring your own headset with a cord. So if you don't have one, buy a set at the airport and get something that's not really bad. We need to get Val back in the air, deploy him to Denmark. I don't think his wife will allow it. Moana 2. Yeah, it's the new. Just came out. No one saw it, I think. Don't forget you can go to the special lounge for business class folks. Here we get all the free booze and awesome food you want. Yeah, but I don't have the. I'm actually going over Finland. Never been to Finland before, so I'm gonna wave to Vilu and we'll have quite a few Medida. Have a few Finns, so I'm gonna wave to them from the airport. But I think I'm only have like an hour layover, and then when I'm coming back, I think I'm coming back through Heathrow. You make sure you have the plugins, Jamie. Plane might not be wireless, so you need to get something that has a cord to it.
I'm gonna have to buy something because I don't own any corded.
Yeah, but you'll get the cheapest, the really shitty ones you got with your phone back in the day. That's felt like they're made out of stones. You'll probably be able to get one of those very overpriced. So if you go by a Walmart and buy a decent pair of in-ears with a cord, you'll be happy. Diane G says, just use the ones they give you. No, they're shit. But Jamie, I need to go pack, and you need to go pack as well and make sure that you're ready to go. And then we're going to see each other in like 16, 17 hours.
Crazy.
Yeah. Enjoy your flight. Don't worry. You will get down some way. Yeah, I don't even think... I'm not sure they will... Well, on transatlantic, they will probably... I can't remember if I got them last time because I just bring my monitors. So...
I love Val. Jeez, Val.
Yeah, bring sure. Well, we do sell underwear in Denmark. When's the first stream? Well, of course, I'll be standing outside the reception with a sign saying "Congratulations and welcome out of prison. I hope you didn't smuggle this time." And see how Iris is getting taken down.
I'll smack it out of your hand if you lighten it up the minute we get there.
We'll probably do something maybe afternoon time. We'll have to figure it out whenever it's convenient. And because let's see how Jamie takes to a transatlantic flight. It's a real rough the first time you try it.
That's what I mean. Like, give me a minute to like get there and readjust to this, because that's such a time difference. It's crazy. It's crazy that I'm flying and then I'll just be like, boop, 6 hours ahead or whatever it is. Is it 5 or
Yeah,
6?
but if you can get some sleep, your body will kind of be fooled because you
I hope
will
so.
arrive with the morning. And do yourself a favor, find the part of the airport, if you have time to do it in Schiphol, where you can see the sun and just stand with closed eyes and look at it for a little bit. Just it'll kickstart your melatonin so you can get easier on the other cycle.
Yeah.
Just ride the white lightning.
It'll be fine. It'll be fine.
Drink plenty of water. Jamie is gonna go on and says, free beer, mama likey.
That's a bad idea.
I'm gonna jump off. You're gonna jump off. Everyone, enjoy the rest of your Thursday. Streams not to be announced, but to be it'll be somewhere. And Sunday, we are working on another Can Read panel show where so far Video Jesus has said yes, thank you. Others might join, hopefully before Sunday. Remember, spade and neuter your PDF files, and it's daylight savings time this weekend, so you're gonna jump an hour ahead.
More?
Gracias. Not for us. It's gonna F you up when you're going back because we don't have daylight savings time till 3 weeks. Bye.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100. Because it is 100% correct.
Checking your other.
So you literally built a cannon?
Yeah, it's pretty awesome.
Go
All right, I'm in love.
back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.